switch this over here. All right, perfect. So at this time, we'd like to thank our sponsor, the Police Credit Union, for sponsoring this lead series. For over 65 years, Police Credit Union has been providing financial solutions to take care of our own, exclusively serving law enforcement professionals and their family members throughout California. They proudly provide banking solutions, including checking accounts, home and auto loans, credit cards, online services, and more. And as your financial partner, the Police Credit Union is committed to helping you succeed financially, whatever your stage of life. So we thank them for being our exclusive one source premier financial partner and for sponsoring our lead series. So with that, my name is Sean Rundle. Welcome everyone and Happy New Year. I'm the Deputy Director here at the California Peace Officers Association, CPRA, out of our office in Sacramento. We welcome you to our first 2021 Leads, which was created as a conversational forum on the onset of this pandemic to keep everyone connected and share ideas and best practices. So we're certainly happy to extend that into 2021. So being just a few days into the new year, our topic today is California Public Records Act, what's new for 2021, which will cover trends and issues regarding PRA, and we're grateful that Paul Coble of the Jones & Mayer Law Firm has taken time to share with us all today. With a background as Deputy City Attorney for Santa Ana Police Department and with 21 years at the Los Angeles Police Department, Mr. Coble brings a focus on labor, employment, tort defense to the civil practice of Jones & Mayer. You may also know Paul as an instructor for CPOA's multi-day Public Records Act and POBAR courses, as well as the online self-paced PRA courses that we've been implementing. You'll also find some recordings of those on our training portal as well. So as many of these classes are converting to virtual going forward, and especially right now after the new year, as we expect to see an uptick in cases, you may see more opportunities for our online PRA, so keep a lookout. So while Paul, in doing CPOA's advocacy, where I can certainly, attest to the importance of today's topic, just as this profession has been, getting used to PRA reforms like 1421 and SB 978 and other mandates, and we know, just a few days ago they had to update their policies for all their use of force policies for anything that had to be could be requested via PRA. And we know that there's going to be some failed attempts from last year that'll return this year. I've already heard some rumblings out of the Capitol about some things they want to reintroduce, some bills that came from Senator Skinner and others regarding what can be released via PRA and everything else. But each agency is also, I know, dealing with, PRA in their own capacity. Many of these recent trends, extend across the state, which brings us to the conversation, of course. So with that, I will turn it over to you, Paul.
I think he got disconnected, Sean.
Oh, okay.
So I think he's trying to get back on.
Okay.
I just want to give him a second.
While he's trying to get reconnected, I'll share with everyone, as I mentioned, doing the legislative work. There was a few proposals last year. One was SB 776 from Nancy Skinner that looks to be introduced that would basically release all of your use of force incidents, regardless of, the outcome, the investigation behind it. It would just have all of those records released. And I know everyone over the last few years, especially all the folks we have that are from records that are on the webinar today. I'll start the new year by saying my condolences. You're dealing with, with 1420 over the last few years, redactions, all those types of things, as well as, SB 978, everything that has to be kind of upfront on your website and all those things. So there's certainly a number of issues that I think Paul will certainly, shed some light on. So with that, Paul, I'll turn it over to you, sir.
Okay, good. Are you going to bring up the slides on your screen?
I will. So I don't know if you have some opening remarks or you want me to pull them up now, whatever you prefer.
I'll just make some brief opening remarks while you're going about pulling them up. In certain respects, the past year has not been an especially busy one for CPRA issues. Certainly at the beginning of the year, when some of the laws passed in the preceding session became effective, we had a lot of things to do, and you're familiar with those in terms of disclosures under 1421 of sustained findings of certain types of misconduct, the things you have to post on your website and things like that became effective last year. But I think to a degree, the impact on day-to-day life and business of the pandemic kind of slowed things down legislatively. However, I think that we have to have our eyes open to the reality that a lot of things that proponents of change in those areas wanted earlier and didn't get are going to be on the table this coming year as we hopefully emerge from the pandemic and get back to a more normal business footing. So I guess I would just say stay tuned, more news to follow. However, there are certain trends and issues that, while they don't represent changes in the law per se, I think are worthy of your consideration. Slide, Sean. We know that commencing last year, you had these requirements to post certain things on your websites, and I know that you have all been busily going about that. Early on, we got a lot of inquiry from agencies about what to post, what not to, and so forth. On any of the things that you're required to post, as well as any of the things that you are just producing in a normal Public Record Act fashion, where you want to redact portions of the document, I encourage that you not do so using a black Sharpie. First of all, I'm the guy that when he was a kid couldn't color inside the lines. If you have me redact a document using a black Sharpie, it's not going to be a pretty result. But more importantly and more practically, if you scan the document that you're either going to post or release over the counter into one of the more recent versions of Adobe PDF that allows you to highlight text, just simply go through and highlight the text that you want to redact. And then the highlight color you select is black, and you automatically have a very neat and tidy redaction. But beyond just the physical appearance of it, after you've redacted a document in that fashion, then I want you to save it in an electronic form. The title of the document -redacted would be perhaps a file name, so that if at any point in time we are challenged in court as to what we redacted and why, it's very easy in chambers, in camera, with the judge hearing the case, to call the document up on a laptop, show it to the judge, and then highlight the redacted portion. And then the highlight color we select for the judge's viewing is no color. And all of a sudden the judge sees what we redacted. We can discuss with them why that was necessary to be redacted, and they'll give whatever direction they give. In my experience, in most instances, they're saying, no, I understand why you redacted it. That should remain redacted. Then you simply highlight it again and select black as your highlight color again and move on to the next redaction. If you don't do it in this way, then the only way to show someone who needs to know what the unredacted document looked like is to do a side-by-side read-through, which can be quite simple and easily done. If you're talking about a 1 or 2 page crime report, gets a little more difficult when, as I had the experience of doing, you're looking at a 400-page internal affairs investigation that someone redacted using Adobe PDF, but then simply printed out the document and didn't keep an electronic version of what they redacted. And even they didn't know what they'd redacted. And so I ended up having to do a 400-page side-by-side read-through. So when you're redacting, either for posting on your website or for production over the counter or by mail to a CPRA requester, that's what I would recommend that you do. Also take note, we underline in this slide the words that materials that would otherwise be available. You don't have to post unredacted on your website anything that you wouldn't produce unredacted over the counter or by hand to a requester. So for instance, If a posted document would reveal a confidential informant or a juvenile offender or a sex crime victim, or would in some way compromise a police safety tactical technique, as you might find in some of your policies, you don't have to produce that and it should be redacted. But when it comes to your policies and procedures and your current standards of conduct, you're going to find that more often than not, the document is going to be able to be posted without any redactions, because there's nothing in there that would compromise any of these things that we just discussed. But please don't feel that you have to post anything that you wouldn't produce over the counter to a CPRA requester. Slide, please. CPRA requests have, increased greatly in volume almost everywhere. And we're finding, as we look around the state at the agencies that we serve, and even some that we don't necessarily serve as their counsel, but they contact us for advice in this area, record staff and custodians of records are often way behind on production. And being the conscientious people that you are, I see you getting frustrated by that, and even sometimes perhaps alarmed by that. I commend your sense of frustration, because when you know that you have something that needs to be produced, either completely or in a redacted form, you want to get that done because you're conscientious about your work, and good for you for feeling that way. But sometimes I have a sense that you may be getting confused between response timelines and production timelines. And the only timeline that the Public Record Act gives us is to respond to the requester within 10 days. Now, we're often asked, is that 10 working days or court days, or is it calendar days? The very simple rule of statutory construction in California, and indeed most other states, is that if a statute says days, then it means calendar days. And if it means some other day, like Monday through Friday or court days, then it means those and not calendar days. In other words, it would exclude holidays and weekend days off. But the Public Record Act says 10 days, and so that does mean calendar days. In teaching the larger class on PRA, if any of you have attended it, you've heard me say how strongly I encourage that you record managers put in place fallbacks for when you're not there. If you're away on vacation or you're out sick and a Public Record Act request comes in, you need to have designated and trained someone on your staff to responsibly deal with that PRA request in your absence. My recommendation is that you have what I call a tertiary process. You're the primary as the record custodian. If you're unavailable for more than a day or two, then someone on your staff, your secondary, steps in your place and handles the PRA request in your absence. If by any chance both you, the primary, and your designated secondary are not available, then the tertiary is by my recommendation, typically going to be the secretary to the chief or the sheriff, because they may not necessarily be schooled in the PRA, but they're used to dealing with sensitive matters, especially time-sensitive matters, and they can either handle it or get a hold of someone who can help them. But have a process where you are, whenever possible, responding within 10 days. And what must your response entail? Yes, we will produce. Yes, we will produce with identified redactions. No, we will not produce at all. That's all you have to say within the first 10 days. And if for some reason, maybe the records are in a remote location and it's taking you time to get to them, and you're not able to make that determination of what your response is going to be within that first 10 days, the Public Record Act, always remember, gives you up to an additional 14 days at the direction of your agency head, typically your sheriff or your chief of police. You don't have to, it's not 14 days or no extension at all. It can be a day, it can be 2, it can be 10, or it can be all 14 if that's what you need. And when you do exercise that 14-day extension, do be sure to notify the requester that you're having a delay in locating and examining the records, and you'll be able to respond by thus and so date and time and let them know. But once you've tendered that response, whether in the first 10 days or by some necessary extension up to an additional 14 days, you're looking at a max possible, my friends, of 21 days in order to figure out solely and simply whether or not to produce. And once you've made that determination and communicated it, thereafter, you're simply required by the law to produce within a reasonable time. And what was reasonable 2 years ago isn't reasonable any longer in many instances because of the volume of requests that you're receiving and the volume of records that is often, not always, but often requested. It takes time. And the best recommendation I can give you is once you've tendered your response as to whether or not and in what form you're going to produce, for your production timeline, go on a first come, first served basis and let the requester know that there's going to be a delay. And to the extent that you're able, give them an estimate of what that delay is going to be. But be conscientious. I know you will. I already know that you are. But if it's taking a while and longer than you would care for as a conscientious custodian, then it's taking longer. And that's just how it is in our current environment. We're seeing end runs, or at least attempted end runs, around the limitations of the California Public Records Act. Instances where requesters, often the actual or quasi news media, people at a university will get together and form a group and say, yeah, we're a journalistic group. That's what I mean by quasi. Are attempting end arounds to get individual officer trends. They'll ask for officer ID either directly, give us the name of the officer, which of course we don't do, or derivatively. And what I mean by derivatively is after you've denied the actual names, then they'll say, well, we want to be cooperative. How about if you just, for the records you're producing, assign an arbitrary identifier number, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, to the various officers whose records you're producing. But remember that the PRA says you have no duty to create a record that does not ordinarily exist. And since I doubt that any of you ordinarily assign anonymous identifiers like 1, 2, 3, 4, 5, 6, 7 to your officers, the PRA does not require you to do that. What the requesters want to do, and I understand this, and I'm sure you do too, what they want to do is to try to say, well, oh my gosh, the police department in city X has one officer with 10 complaints in the last year. Oh my God, what are they doing about this? We're not obliged, however, to assist them in that effort by assigning anonymous identifiers. And I don't recommend that you begin doing so. You don't have to create a record that doesn't exist.
Hey, Paul, we had a question.
Please.
When there is conflict between different release requirements, CPRA versus penal code, which takes precedent? Example, PRA requires release of arrest info. Penal code says this is criminal history and therefore not releasable. Well,
you must have a crystal ball, because that's pretty much the next thing I was going to talk to you about. So as we move forward, we have a Southern California law firm that is making CPRA requests really throughout the state for months-old arrest information, arrestee information pursuant according to them, Government Code 6254F1, which, as you may recall, is that portion of the Public Record Act that says we have to release arrestee information, name, date and time of arrest, booking charge, bail, so forth. Those things that you ordinarily and have for many years released. Slide, please. Two cases I want you to be mindful of because they are the two seemingly conflicting cases that we fight over on these types of requests for arrestee information. The first is Los Angeles v. Superior Court, Kuzar. In Kuzar, there was a request to the Los Angeles County Sheriff's Department for records relating to individuals arrested by two identified sheriff's deputies during a 10-year period, and in which the crime for which the arrest was made was one where the victim, or pardon me.
One last thing I wanted to do. No problem. Oh, Patrick, oh, yeah. We're talking, after I did that, I forgot to mention.
Whoever is speaking now, could you please mute your mic? Thank you. So clearly they were talking about 148 arrests, 243 arrests, things like that. And in Kuzar, it was held that the records to be disclosed are limited to current information and contemporaneous police activity. Now, Kuzar said that without identifying what numerically they meant by current or contemporaneous. And we've informally over the years polled agencies around the state, typically by posing the question at classes on Records Act that we teach, asking how long they release records as being current and contemporaneous. And it generally speaking falls around the 1 month mark, just by way of anecdotal practice. So there's Kuzar that would I think you can see militate against producing these volumes of arrest records from 3 months ago, 6 months ago, a year ago. Next slide, please.
We have another question, Paul.
Please.
If someone is released per 849.5 PC, can the information be redacted from the arrest log released to the public?
There's no law directly on point, but assuming that the that the release occurred and the arrest became a detention only before you would otherwise post, I think that you could. And if somebody wants to fight over that, let's have a judge tell us that it's not all right. Because you arrest me, and then you find out I didn't do it. I've had that during my own policing career. I had this happen a number of times. We had some hapless individual that we arrested for purchasing rock cocaine. And just so you don't think we're complete idiots, this was back when rock cocaine was brand new on the streets of Los Angeles. And we ultimately, after we had booked him, determined that what we had booked him for was possession of aquarium gravel. Well, it looked like a rock, but it wasn't a cocaine rock. Clearly, he had, and we 849'd him out the door. One of the glorious and logical things about the law is that the penal code not only allows us to arrest, it allows us to unarrest. I would be comfortable, but I would encourage you to consult with your own agency counsel on this question and see and follow their guidance. But and certainly if they want to discuss the issue with me, I'm always available to help them out if they wish. But if you were my client agency, I'd say I think that what you've posited, what you've asked, makes sense. Because if you've arrested me and then determined I didn't do it, why should my name be out there as somebody who committed a crime? So, but continuing on, in the other case I want you to be aware of, which is the one that this law firm I'm speaking of relies upon, is Fredericks v. Superior Court, which followed Kuzar by several years. In that case, the request was under 6254F2, not for arrestee information, but for complaints and requests for assistance, basically CAD data for a 6-month period. And in saying that San Diego PD had to release those records for the 6-month period, the court in Kuzar, the appellate court the appellate court in Fredericks, said that they rejected the current and contemporaneous analysis of Kuzar. We think that a significant point of distinction there is that while Fredericks sought CAD data, Kuzar sought arrestee information, which, as the person who asked the question points out quite ably, ceases to be current and contemporaneous and morphs, if you will, by simply the passage of time into being criminal offender record information. I've always felt and believed that the public policy served by 6254 F1, the required release of arrestee data, is so that American law enforcement, or at least law enforcement in California, in our free society, can't make a secret of who they scoop up off the street and lock up without telling anybody. In the absence of something like 6254 F1, it would not be a short step for us to find ourselves doing things like certain South American countries and the so-called disappeared. They get scooped up by the government and are never heard from again. This puts out there who we've arrested and why. And I think that's the public policy that is served. Next slide, please. Again, the latter two of the appellate courts, Fredericks, does not specifically overrule Kuzar's current and contemporaneous language. One appellate court cannot overrule another appellate court. One appellate court can say sometime after it had rendered an appellate decision, oh, oops, our bad, we got that wrong, and undo it in a subsequent appellate court decision by that same district court of appeal. But one district court of appeal in California cannot overrule another district court of appeal. Also, while Kuzar dealt, please back up. While Kuzar dealt expressly with arrestee information, as I've just pointed out, Fredericks dealt with call history or CAD information. Slide, please. There have been mixed results in this fight in various courts. This law firm has been all over the state. A court in some appellate district could rule other than Los Angeles Kuzar or San Diego or Oregon San Diego Fredericks, and could come down one way or the other. I cannot guarantee what that outcome would be. Some jurisdictions have elected to simply produce the older, more dated arrestee information being requested, rather than run the risk of losing at litigation and run the risk of having to pay the requester's attorney fees if they did lose. And some local jurisdictions have elected to contest the issue and have lost. And some have done so in one. Slide, please. We're currently litigating this ourselves for the Citrus Heights Police Department in the city of Citrus Heights here in Sacramento County, where our Northern California office is located, and in the case of Citrus Heights, where we serve as city attorney. We very carefully went through this with our client and made sure that they understood the risks and rewards, and we were given direction to litigate the issue. As a matter of fact, today was the deadline for opposing counsel to file their opening trial brief, and they didn't. So we'll just see how that comes out. We have a hearing set for next month in Sacramento Superior Court. What I would encourage is that if your agency receives such a request for dated arrestee information, feel free to contact me and I'll let you know whether or not it's the firm I'm speaking of. For obvious reasons, and I see a request for the name of the firm. If you want to know the name of the firm, the first slide gave you my contact information. I don't want to get into a battle with this firm over expressly and by name criticizing them in this potentially public forum. So if you want to know, I'll be happy to tell you, or your city attorney or county counsel. There has been a great deal of discussion of these types of requests and of the law firm that's been making them on the city attorney listserv. That's a sort of chat forum, a blog, if you will, of sorts, that city attorneys throughout California go to say, hey, is anybody facing this or thus or so issue? Or, hey, here's something that I've experienced. I want to share it with you. So your city attorney and your county counsel can certainly avail themselves of the extensive commentary on this issue that has gone on the city attorney listserv. They should know how to reach this. But if you do receive such a request, and particularly if it is from your firm, do encourage your city attorney or outside legal counsel to either contact our office or to go directly to the city attorney listserv. We'll be happy to provide whatever assistance we can. We think that the odds favor us prevailing on our case in Sacramento County Superior Court. But I would just say to you, if you ever have an attorney who guarantees you an outcome, you've hired the wrong attorney. You know, you stand in front of a judge, and there's a reason they call him a judge, because it's called judging, and they apply what their best judgment is of the law. And lots of times that agrees with me, and other times it doesn't. So be aware of that. I think until we have some clear guidance, and it may require taking a case to the Court of Appeal, and it may require even going beyond that to the California Supreme Court if we have differing district courts of appeal. That typically sets the stage for the California Supreme Court to be the tiebreaker, and that may be necessary on this issue. But I think, as I believe all or most of you do, that it represents bad policy to be reaching into the past and letting go groups of large bodies of arrest data. I think in the case we're litigating in Citrus Heights, they wanted 30 days worth of DUI arrests. Well, why do you suppose they wanted 30 days of DUI arrests? I don't know, but it sounds like the kind of requests we used to get years ago from a firm that, before 6254 F1 was amended to exclude address, they were selling the information to criminal defense attorneys to make solicitations, or to driving schools, or to drug rehab programs, to reach out to these arrestees and offer their services for a fee. I fail to see what sort of sociological purpose is being served by this data, but maybe there is, and I just don't see it. I still think it represents bad policy, because as the person who posed the question earlier pointed out, this does, my word, morph. It transitions, it evolves into criminal offender record information. And all of you folks know very well, as do I, how closely guarded, and for very good reasons, CORI, both local and state, is treated in California. So those are kind of the trends that I'm seeing. Let me just pause for a moment and say to the person who had posed the original question about criminal offender record information, if I've answered your question. And as well, if any of the others of you have any questions, and the person who asked for the name of the firm, I believe Sean was good enough to provide you my email address. I'll be happy to share that with you one-on-one, as well as be of any other assistance that I can, if it's of any use to you.
So Paul, a response from the first question from the person who asked it. He said, I believe the desired outcome is to sue a city not providing the arrest info, hoping the city will settle out of court prior to trial. Can you, and then let me see if I can unmute him so that he can ask more. Let's see.
Thank you, Paul, for taking that question. It's actually a two-part question. First of which is the topic that you discussed, which you did a great job explaining and gave me some insight that I was not aware of. And I really like the way you did that. Second component of that is when there is conflict between, let's say, a penal code section and a government code section, is there one that supersedes the other?
Well, actually, there is, and the Public Record Act recognizes that at, I believe it's 6254K, I believe, but it's in the Public Record Act, that the exemptions from disclosure include any disclosure that is otherwise prohibited by law. So if there's a penal code statute that says don't do this, and the Public Record Act doesn't specifically address that type of record, then under 6254K, you turn to that penal code section and you say, under the Public Record Act, this is exempt from disclosure because this parallel statute in the penal code forbids the disclosure. Does that help you?
Yes, it does. Absolutely. If there is, though, and I'm sorry for not having a specific section in mind at the moment. If there is a section in one code, let's say it's the penal code, that says you shall release this type of record, and there is a specific section in another code that says you shall not release a specific type of record, and I'll say like a juvenile information, for example, where there's just obvious conflict between the two, is it we just have to wait for the court to decide, or what do you recommend?
I would, if you encounter such a situation, my counsel to you would be, if I were your attorney, would be to go with the non-disclosure, explain that to the requester, and then we'd probably have to let a judge find out. However, having said that, or have a judge rule on it, having said that, in most instances, really, that I've encountered where I haven't, where the penal code says, to use your example, release this, typically that release is ordered to a particular class of persons. The victim, the victim's insurer, the victim's representative, sometimes to the parents of a juvenile, things of that nature, sometimes to another law enforcement agency. In other words, there's the right to disclosure is based on a statutorily identified need of the requester to know. But if you do ever run into a situation where the penal code says, you shall release, and the family law code says you shall not, then you have to, a judge is going to have to call the balls and strikes on that one.
There's, sorry, a question, I don't know if you see in the chat box. Does 6254K apply to state law or federal law or both?
Both. If there's a federal law that says, don't do this or we'll send you to the federal penitentiary, you don't do it. Yeah, it covers both.
With that, I'll see if there's any final questions, either put in the chat box, or we'll monitor for people that are raising their hand. If anyone has any final questions or thoughts or any trends you're seeing locally, that would be good.
I see Bianca has a question that's come up on my screen. Thanks. Well, you're welcome. Again, if I could see that question on the screen again, it went away before I read it all.
So her first one was the 6254K that I just asked, and then she said SB 1421 is specific to federal law, so that the clarification is helpful for general PRA.
Yeah. You know, I suspect on 1421, just my editorial comment, when it first became law and it was pending being effective, we were all understandably in an anxious state of mind. But my prediction back then, and I believe we're seeing it come true, is that 1421 for the proponents of it was like a shiny new red sports car with a full tank of gas, and somebody's handed you the keys. And it's going to be a lot of fun to drive for a while, but the shine begins to wear off, and when it needs to be washed, and when the gas tank needs to be refilled or needs to be serviced, maybe it's not quite as much fun as it was. And by that, what I meant was, and what I believe we're seeing is that the disclosures, by and large, not completely, there have been exceptions that have not painted certain agencies in a good light. But by and large, the disclosures under 1421 have been revealing that California law enforcement, California chiefs and sheriffs have been doing their job. That the people who have those types of sustained acts of misconduct have been dealt with appropriately. Unfortunately, for those who are antagonists toward public safety, you'll never be able to convince them that there is no there. They'll just continue to come up with laws thinking, well, we found some place to hide what they just have convinced themselves is there. And so as their public servants, we'll just have to continue to roll with that and do our best. But we're not getting the bloody nose behind those disclosures. And that's not by luck, that's because you and your agencies have been doing the job the right way.
We'll see. So, open forum question. How are other agencies managing the release of ancillary types of records responsive to 1421? We have an extensive backlog. It looks like San Jose PD for primary records and ancillaries. Just wondering if other agencies are releasing every type of record required under SB 1421 or have some strategy for release. So if there's anyone that can lend to that question.
I think a strategic release would be the right characterization. Technically, and at the end of the day, if they want the entire file on that IA report, including the addenda and so forth, they're going to have that. What we have done in some of our agencies is where it is particularly voluminous, as it can be, as you know, to first produce just the main body of the report and tell the requester, here's the main body of the report, let us know if this meets your needs. And a lot of the time it does. Obviously, sometimes they come back and say, no, which part of everything do you not understand? And then we produce everything in as timely a manner as we can. But asking somebody if the body of the report suffices for their needs opens the door for them to say, no, it doesn't if they wish to. And I'm a firm believer of the old saying that in life you get half of what you ask for and none of what you don't. Ask them. The worst they can say is no. Give me everything. We'll say, okay, fine, understand. Happy to do it. We'll be in touch. And then you truly do get to it as in as timely a manner as you can, and as I know you are doing.
And well, I'll see if there's any final questions. I'll remark too that there's that part of what was proposed last year by Nancy Skinner's bill was to request every incidence of officer misconduct and dishonesty and those types of things. And when they pushed for that bill in committees and whatnot, they said, and the sponsors, the ACLU and others, said we're trying to get every proof, every proven case of misconduct. But what the bill actually said was it actually didn't ask for sustained records. So I and some of my colleagues and other attorneys, we pushed back to that committee and said, actually, you're not asking for proven records because you're not asking for the legal threshold, sustained records. And so they kept going back and forth through a number of iterations. And then obviously there was some blame put on the lack of time for the, legislature's work under the pandemic and other things. But it wasn't ideally drafted in any way, and the language was very problematic. So there's going to be some attempts as to that I expect for this year to try to extend that, of course, from Nancy Skinner, who was the author of 1421. So
Yeah, that'll be coming back at us, I'm sure.
yeah. So look for that for
Yeah.
for legislative updates from
Sean,
CPRA.
an interesting little historical irony. The Public Safety Officers Procedural Bill of Rights Act that gave all these rights to officers. Okay. One of the primary and strongest supporters of it back in the day was the ACLU.
Interesting. Yeah, there's a question, did that bill make it out of committee and onto the floor? And it did, and it died there on the floor because there was some problems with it. But there was also ties to it to Stephen Bradford's bill, the decertification bill, they called it 731, that would have actually changed and said basically decertification will happen in addition to the other language or basically the other components of changes made by SB 776. So in other words, if both of those bills passed together, the changes that Skinner's bill would have made to release of all records would have also played into how officers are decertified and other things. So you can see where the dots are connected, and we expect again that those to be connected this year.
Absolutely.
So
do I have, I see in chat, there's a couple of entries. Are there any questions in there?
I think I caught most of them. I'll ask maybe any of the other staff if they saw anything different or anything different to them, but I think we caught everything that's in the chat box. So if there are no further questions for anyone, for Paul or anyone, let me just throw up some stuff that's coming up here soon from additional virtual trainings that we have coming up. So you'll see Andy Brillo, most of you know, who does the author of Police Promote and others. He's going to be doing a promotional preparation, just a quick 2-hour promo prep on January 20th from 1000 to 1200 hours. The next installment of this lead series will be next month, February 2nd. The author of I Love a Cop, Dr. Ellen Kirschman, and then in February, which is actually great, we partnered with the U.S. Attorney's Office here in the Eastern District to do a search and seizure series on Fourth and Fifth Amendment stuff and cyber crimes and serving electronic warrants and those types of things. So especially for all of you, get your detectives to participate in those things. And then you'll see all of the bills that we're talking about that are going to be proposed again for our virtual legislative summit that'll happen March 3rd. Many of you have attended that in person, but unfortunately, obviously, we can't hold that. But the links to our training page and to the legislative summit have been put in the chat box by our staff. So thank you for that. And with that, we also want to thank again our sponsor, Police Credit Union, for sponsoring our lead series. And unless there's any final thoughts or questions, we hope to see you next month. And again, nice to see everyone again virtually after the holiday break, and Happy New Year, and stay safe out there, and we'll see everyone soon. Thanks, and have a great rest of your afternoon.
Thanks, Tom.